Hello.
And welcome to the Alternative Dispute Resolution Certification Working Group. And I just want to remind everyone that this meeting is being recorded. Angela, would you please take the roll?
Yes. Armstrong, Coulter,
Here.
Curtis,
Here.
Dinkin,
Here.
Dubow, Ellis,
Here.
Dr. Getz,
Here.
Higuchi,
Here.
Hodgson, Jones,
Here.
Kelly,
Here.
Kopaken,
Here.
Cruz, Lowe, Judge Lucky,
Here.
Palevsky,
Here.
Judge Kushon,
Here.
Robertson,
Here.
Tuckman, Welch,
Here.
and Yamshan.
Here.
Thank you.
Thank you, Angela. Next on the agenda is the call for public comment. The State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. Angela, would you please provide the instructions?
Yes, for those that are participating by Zoom video, you can virtually raise your hand at this time if you'd like to give a public comment, and the State Bar staff will call you in the order that your hands are raised. If you're participating by phone, please dial *9 to raise your hand. Each speaker will have 3 minutes, and the on-screen timer will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining. So at this time, if you'd like to give a public comment, please raise your hand. I do see one raised hand at this time. Kai on. Kai, your mic has been enabled.
Yes, please go ahead.
Good afternoon, all members. My name is Kai On from Sacramento. I would like to talk about State Bar's integrity issues. Sacramento DA office and SPD provide me fake information about the death of my father, Wun Kong On. DA case number 99F08735. I filed complaint against Sacramento DA Mr. Tien Ho and Attorney General Mr. Robert Bonter because they did not investigate. I reported the incident to their agency back in January 2024. In February, State Bar used an incorrect reason to dismiss my complaint and claim it is a civil matter. Then State Bar intentionally keep delaying to process my complaint review request. In September, State Bar closed my complaint without reviewing DA case 99F08735 to confirm my father Wun Kong On was the victim, and Jung So Fong was the defendant that sentenced for hit and run that killed my father in the case. Also, the letter from State Bar has no name, no title, and no signature. I cannot verify if my complaint were closed by authorized State Bar staff. State Bar is helping to cover up a Sacramento law enforcement scandal. I have requested an internal investigation, but it didn't happen. I just emailed the detail and evidence to this work group. All work group members, why you serve State Bar that has misconduct issue? How State Bar is qualified to examine and regulate licensed attorney in California? Please help to uphold justice, and please help to ensure an internal investigation will be conducted inside State Bar. Chair, Judge Pichon, could you please provide comment on this incident?
Could I please what? I'm sorry, what did you say?
Could you please provide comments on this incident?
I'm sorry, this is the wrong group, but I'm going to let Ms. Ellis speak to you.
Mr. On, we can follow up with you and direct you to the appropriate department. Thank you.
I understand, but the problem is why you serve the State Bar that has integrity issue.
Sir,
That's why I want to have your comment about that. maybe I talk to you next time. Thank you, Honor.
Okay, thank
Thank
you.
Thank you.
Angela, is there any other member of the public who would like to speak?
Yes, I do see one other person. Bruce Winkleman, your mic has been enabled.
Good afternoon.
Afternoon.
In an effort to avoid all of you thinking that this is a thankless task, thank you for working on this so that it is, both informal and unrecognized what you're doing. I'm an attorney and a mediator. I've been practicing since 1986. And as a mediator, I'm concerned about both the multiple tier ethical guidelines and the unrelated to quality issue in terms of the public perception of what tiering would mean. And I know that this group has thought about that, and I just wanted to iterate that concern. In addition, the complaint procedure, I've mediated many cases, and I've been involved in many cases as an attorney representing clients. And I do think that as an attorney representing a client, if there's an issue with a mediator during a confidential mediation process, it is my job as the attorney to work with the client. And I do think that this group may want to consider a representation by counsel during a mediation where a complaint is lodged, perhaps because the mediator was too evaluative or the client didn't understand the process of mediation, with a party who is pro se. And I guess the final concern that I'd like to raise is just how a mediator who is running their process and has not had complaints in the past suddenly gets a complaint through this new process that is reported. And it is important that mediators adhere to high ethical standards. There's no debate about that.
30
But
seconds.
if there is a situation where there's perhaps not a good faith player, how does the mediator protect and defend his or her reputation in the process in a confidential setting? And I know that this is an issue of concern, and I'm running out of time. I appreciate everything that you all are doing on your end. Thank you.
Well, thank you very much. Your comments have been heard. Angela, is there
anybody?
any other member of the public who would like to speak?
I do not see any more raised hands.
All right, thank you very much. Next on the agenda is the approval of the August 20, 2025 open session minutes. Are there any corrections or modifications to the open session minutes? If not, may I have a motion and a second for approval?
Moved.
Oh, thank you, Mr. Kelly. Is there a second?
Lucky, I'll second.
Thank you, Judge Lucky. Angela, would you please call the roll?
Armstrong, Coulter,
Yes.
Curtis, Dana Curtis,
Yes.
Dinkin,
Yes.
Dubo is absent, Ellis,
Yes.
Dr. Getz, Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Popagan,
Yes.
Cruz is absent. Lowe is absent. Judge Lucky,
Yes.
Pulevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Abstain.
and Judge Pishon.
Yes,
The minutes have been adopted.
thank you. Next on the agenda is my chair's report. Usually I don't have a chair's report, but I do have a few comments that I would like to make at this time. The first is to congratulate one of our own. As many of you may already know, Dr. Jack Getz will be receiving the L. Randolph Lowry Award um, at the Southern California Mediation Association Conference this weekend. The award is given to a member of the dispute resolution community who has honored and inspired us through their passion and dedication to education in the field of dispute resolution. It is so well deserved. Congratulations, Dr. Jack.
Thank you so much.
I also want to say that as was true with the previous subgroups, the three new subgroups have and their leaders have done an admirable job working on the new recommendations. And you are all to be commended. I read how many times you met and all of your discussions. We are all aware, because we're in it together, of how difficult it is to start from the ground level trying to create a workable product. We want to hear everything about what you've done, but I just want to remind you at this time that since we want to hear about and discuss the work of all three committees, we have to be aware of our time. So staff and I will remind you when we have to move on. So I hope that you will not be offended when we remind you that it might be time to move on to the next topic. So next, we have our staff report. And does the staff have anything to report at this time?
I do not, Your
Nothing either, Judge Pichon. Thank you.
Okay, all right. So we'll move on to the business and item number 2.1. It's allotted 15 minutes, and that's discussion and project timeline and possible action on amending working group charge for submission of recommendations to the Board of Trustees. This will be presented by Ms. Ellis.
Thank you, Judge Pichon. Good afternoon, everyone. Alan and I actually wanted to take this time to update all of you about our timeline. As you well know, for the last 8 months, you've all been working very hard, actively participating in the working group meetings and the various subgroup meetings. So as we discussed in the last working group meeting, the plan is to send the proposals out for public comment. We are going to post them for public comment. The plan is right now around December 18th. So a few days after our last meeting of the year. The plan is for the proposals to be in the form of state bar rules and the standards. It will be out for a 60-day public comment period, which will take us approximately through mid-February. And then we will ask all of you to return in March and April for maybe 2 to 3 meetings to review the public comments and then just also discuss any revisions to the proposed rules and standards. The plan is to submit the working group's final proposal to the Board of Trustees in May 2026. So to that end, as you may recall, back in February at the first meeting of the working group, you adopted a working group charge that guides the committee's work. And the charge is currently stated and posted, states that the working group will submit its final recommendations to the Board of Trustees in September 2025. So we need to update the charge. So what we would like to do by motion in this space is to amend the charge so it's red line. So the date or the language can say, and I could share my screen, that the working group will submit its recommendation to the Board of Trustees, just removing any reference to a date. And I could share my screen with you.
Okay, while you're doing that, Mr. Kelly?
Just going to say I'd like to move that question. I move that that be adopted as amended.
All right. And everybody, can you see the screen? The document?
Yes.
Is there a second?
Second.
And Angela, would you please call the roll?
Armstrong, Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois, is absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopaken,
Yes.
Cruz is absent, Lowe is absent, Judge Lucky,
Yes.
Palevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Kushan.
Yes.
The motion carries.
Thank you very much. We'd like to take the next item out of order. We'd like to move on now to item 2.4, and then we'll go back to the other two. That is because this one has a number of recommendations that are ready, and they're ready for possible action if the group decides to do that. So it's a report and possible action on the program administrative subgroup, and that's Mr. Kelly. Would you please make the presentation?
Thank you, Judge Pichon. So we were asked by staff to have this ready for this meeting, and we worked really hard, and I want to thank all the members of my subgroup, Ms. Kopekin, Professor Robertson, Ms. Hodgson, and Ms. Coulter, because we did a whole bunch of written work before and after each of our 3 meetings, which is how we managed to get a rough consensus on all of the, I count about 34 different points, which I'm going to try and present to you in a very abbreviated fashion, assuming that you all have had these already since Friday evening and would have read them in detail if you wanted. But I believe staff is going to also put these up on the screen. I will go through the process I'm suggesting, unless there's a strong objection, the chair rules it out of order, or whatever, is that these be up on the screen, that I simply summarize briefly each of these as you see them, and that I ask you to circle or just write down the number and letter, if there's a sub letter, on anything that you have such strong reservations about that you would not vote to approve these as presented. And then I'm going to suggest that I make a motion and somebody second to adopt it as is. And if there are people who want to make friendly amendments to that, they can do so. And as long as I and the second both say, yep, that sounds like a friendly amendment, let's just change the wording, that sounds better. Staff can do that in real time and we can adopt these. At least our goal is to try and adopt these today. And I'm told that I have an hour, but I bet it's going to be less than that and seem like a lot less. So unless the chair rules that it's an inappropriate process, that's the way I'd like to proceed.
It sounds very, very, very good, Mr. Kelly.
Okay, so here we go. You can see it presumably on the screen. Please do make a note of anything that you have such strong objections to that you would vote down a motion to adopt these, and then we can go back and talk about them if necessary. Number 1, separate certification for mediators, arbitrators, etc. 2, no separate certification of subspecialties like divorce or employment. 3, State Bar staff administering the program should have ADR training or experience. 4, recertification every 3 years, staggered. 5, requirements for practitioner applications and recertification. A, basic profile information, including any organizational affiliations. B, attestation of completion of the baseline requirements, including a list of training and experience with sufficient detail to be verified if audited. And I'll talk about a later compromise we made about should people have to list the particular cases that they're claiming for their experience. We decided to go with attestation under penalty of perjury instead of that. So I'll mention that later. That they are familiar with and will comply with the applicable ethical standards, disclose any, excuse me, that was C, 5C. 5D, disclose any professional licenses and whether revoked, suspended, in discipline, etc. 5E, disclose any prior discipline. F, excuse me, that was E. F, that this is submitted under perjury, under penalty of perjury. I mentioned that was a trade-off. Several of us didn't like the idea to start with, but made a compromise in favor of under penalty of perjury instead of requiring the listing of each individual case and who the parties were in initial applications. G, fingerprinting not required. 6, requirements for provider organizations familiar with and will comply with the applicable provider organizational ethical requirements. B, require its arbitrators to comply with the applicable ethical standards. C, require its mediators to comply with the applicable rules. D, lists. Is that a question or comment, or is somebody just coming off a mute? Let me go through this if I might, and I'd ask that everybody would mute unless they really don't like what's going on. Okay. 6D, that the provider organization lists prominently on its website where to file complaints. 7, review and approval both for the initial application and recertification should include A, prompt acknowledgement of receipt by the State Bar, B, notice of application being incomplete or inadequate, an explanation of why and time to cure, C, a 3-month time frame to approve or disapprove, D, to include an explanation with any denial. 8, reasons an application can be denied would be, they would include anyway, A, they didn't meet the requirements, B, they didn't pay with a 30-day notice saying, hey, you got to pay us, C, didn't renew on time with reminders to be sent, D, a verified violation of ethical standards. Verified was important for us, verified violation. E, prior discipline in the certification program or any licensing or professional organization. F, a verified lack of candor. Polite way of saying they lied on their application, I think. 9, if denied, an applicant can request a review and provide an explanation of why they think the State Bar got it wrong. 10, practitioners and provider organizations have an ongoing duty to comply with the rules and standards and disclose any information that might affect eligibility, an ongoing obligation to do that. 11, we recommended, and I guess that's a request, that we're recommending that public comment be requested on whether initial trainings, not continuing education, should be required to be real-time, participatory, whether in person or online, as opposed to simply watching a webinar. That's not a recommendation that it be a standard, but it's a request from us to go out to public comment on that issue. 12, that the State Bar website should give the name and tier level of certified practitioners and provider organizations and list the general reason for any revocation or suspension. 13, certification rules should include that certified practitioners and provider organizations can be audited. 14, lower fees for practitioners who do only pro bono. 15, we again recommend that there is a request for public comment on a fee structure for provider organizations that would have them pay the sum of all the amounts their individual panelists would pay with full credit for any panelists that are individually certified and have already paid their own fees. 16, that fees should be the same for mediators and arbitrators, no distinction. 17, that the State Bar should create an advisory panel, including practitioners from different backgrounds, organizational sizes and types, and areas of expertise to help guide them in administration of the program. So that's a real quick summary and rundown. Hopefully you've had a chance to read this beforehand. You've also seen it in front of you. You've now heard me summarize things. So if I could get the screen back from staff at this point. Daniel, please.
Thank you, Ron. My first question is basically clarification. 5A, listing ADR organizations with which one is affiliated. And I apologize for my voice today. I know I probably sound bad. Does that just include, say, providers, or would that be different ADR organizations such as county bar sections, ABA sections, things like that?
I believe the recommendation was any organizational affiliation.
Okay, thank you.
I mean, you don't have to, but that was our recommendation, that's the request, that all organizational affiliations be listed.
Yeah, it's fine. I just asked for clarification on that.
Yes, sir.
Another thing that caught my eye was in terms of being able to document actual training subject to audit. People have been doing this for a couple of decades now. Probably cannot go back and document their early trainings. And some people in this group have probably provided several thousand hours of training, which would be difficult to document. The Tiers group has been talking about the honor system for most things. So that would be my comment on that. I think a very strict documentation would be pushing things a bit too far.
So, Mr. Yamshon, if I might interrupt you for a second.
Please do.
If there are strong objections to the process I laid out, which is to say, I want to make a motion saying we adopt it as is. And if it doesn't pass, then we'll go back and talk about each individual item, and I'll try and catch up with who has the most objections about which items, and maybe we'll take those out and see if we can pass the rest of them. We're not going to be able to discuss each one of every one of these 34 points in the hour that has been allotted and take a separate vote on each one of them. So
understood. Thank you. So I'll save my other comment for later.
And if that's objectionable to people, maybe you could raise that and we can say that doesn't work. And what else do you suggest to try and get through all of these in the hour allotted? Mr. Tuckman, please.
Thank you, Ron. A lot of work, obviously. I can see went into this. On 6B and C, a clarification. 6B suggests that the provider organizations require its arbitrators to comply with the ethics standards for neutral arbitrators and contractual arbitration. And C is that the provider organization requires its mediators to comply with the rules of conduct for mediators adopted by the State Bar. My question is, are all arbitrators on the roster of that provider and all mediators on the roster of that provider, regardless of whether they're located in California or individually certified, is the expectation that the providers will mandate the application of those ethical standards and rules of conduct for mediators in all cases for all members?
So I'm just looking at the statute, which says that to be a certified provider organization, they need to verify all of the following: that the firm, provider, or practitioner requires at a minimum its mediators to comply. It doesn't say anything about out of state, in state, international, I think this is a big topic. And all we did was try to figure out what the statute currently seems to require, not modify it. We did talk about what about out-of-state practitioners. And we tried to resolve that. We didn't have a consensus. Anything we couldn't reach consensus on, and that was a fair number of things, which you may read in the staff report, that many of us thought were important, is not in our recommendations. And this recommendation, we believe, simply tracks the statute. I don't know how else to answer it. I think there should be a more of a discussion about, should any mediator in Hong Kong be able to get a state bar certification? Seriously, I know a mediator who has moved out of state. His entire practice is California mediations, and he doesn't live here. What do we do with that? I think that's a big discussion. And if this needs to be taken out to have that discussion, we can do that. We thought what we're doing was just following the statute. I don't know if that clarifies it sufficiently, Mr. Tucker.
Yeah, thank you. It does answer my question. The provider group did talk about this issue as well. It does present some problems.
It absolutely does. And if you think that this is so objectionable, we should take it out and wait till the provider group goes through this in more detail. I'm certainly amenable to that. We don't have a motion on the floor, though, and my notion was I would make the motion that we adopt it as is. If there's a second, then any amendments that come in and are accepted both by the maker and the second, we would just say, oh, that sounds like better language. Sure, let's do that. Or let's drop this. And otherwise, we'd adopt anything that we can that remains. So that's the process I would recommend, unless the chair thinks that's a terrible idea. So having made that proposal a couple of times now, I move that we adopt the recommendation.
Excuse me. Ron, there's three other
Her
hands
hands
up. You may not be able to see them.
Good enough. Thank you. And
Sure.
let me say,
I think
Dr. Getz, please.
Thank you, Ron. And I don't, ready to adopt it as is. But I think a significant comment that, and I'm not sure where in your process it comes up, and it has to do with 5G.
Just so everybody's on the same page, we're talking about fingerprinting.
Live scan, yes.
Fingerprinting live scan, we recommended not be required. Yes, sir.
I agree with that. But I have a comment, and I didn't know where in your process that comes up.
Let's do it now. Go for it.
All right. Thank you so much. So, we face sort of this issue at MC3 as well. And first, by the way, your subgroup did a tremendous job. I go through this and I go, wow, that's a lot to handle in such a short period of time. So I really appreciate the work of you and your subgroup. But on live scan specifically, we have a situation where, for instance, local courts often require live scan. And it is sort of a pain to go through the process, and I agree. But if you can think about it from a program administration standpoint, if we don't require live scan and local courts do, you could have a situation, and I admit it may be far extreme, but it also could be very risky if it happens, where someone is turned down as a mediator from a local court because they didn't pass the live scan or didn't meet whatever requirements the local court had, and turn around and say, okay, I can, since they don't check for this at the state bar level, I can go ahead and get certified by the state bar. And that, I think, could create some risk for us, further on down the line. And I do think, and we came to this at MC3 was not allowed to use the live scan system because we weren't connected with a governmental entity. We faced this, and we sort of decided as a group that the public would have some expectation that there would be some kind of background checking. And so what we did, which may or may not be the right solution here, is we engaged a firm that does background checks for employers. And essentially what they did is they did criminal checks. Yes.
In the interest of time and getting through the 34 points, here's what I'd like to do. I'd like to see a quick show of hands. How many people would like to reverse the recommendation from the subgroup? Show of
Ron,
hands
when
and
you say
require
reverse-
live scan or some background check.
Well, this is live scan.
Okay, yeah, on the question of live scan, how many people would like to reverse the recommendation from the subgroup?
But that wasn't my recommendation. I'm sorry, Ron. You're
Oh.
misinterpreting what I said. Totally.
Okay, I apologize.
You took it as very oppositional, and it was actually in support of not doing live scan.
Okay. Oh, I'm sorry, I misunderstood.
Yes. So my point is, the public has some, I think, expectation. We've done some kind of background check. There's alternatives to live scan. They're less burdensome on the applicant. And I wondered if your subgroup would consider at least the recommendation can stand as is, no live scan. But if you would consider reconvening on the issue of looking at alternatives that would meet the public expectation that there's some background checking that the state bar has done. That's all I had to say. So thank
And
you.
I can just say that I'm not willing to reconvene on that issue until and unless we have public comment. And then I expect we will be hearing from the public and figuring out, you know what, we got to go back to the drawing board on any of these issues. And you've raised something that I think is an important point that I think we're going to need to discuss later, which is reporting requirements from local court programs and or provider organizations to the state bar and maybe vice versa. That's a big issue that I'd like to bring up at the working group as its own issue. And I'd like to put it on the agenda for another meeting, but I want to try and get through as many of these points as possible. Ms. Kopekin, please.
Yeah, it's Copaken. Yeah, so I want to raise an issue that hasn't been outlined by Mr. Kelly in the things that we agreed on. We spent about 75% of our time talking about an issue that I think is extremely important, that if you read all the preamble to our recommendations, you will get a flavor of, although I think not a complete picture. And that is where the complaint process for a certified mediator or other ADR provider might impact, if at all, whether there's a court process. So for example, I administer the Northern District of California's ADR program. We have a number of ADR providers on our panel who potentially would become certified mediators. In fact, I've encouraged most of them to do it and been really promoting this program with them. However, from the outset, it was my understanding and expectation that the complaint procedures that the courts had in place would be exempted, or that the court mediations and court early neutral evaluations in our program would be exempted from the complaint procedure. I think that's consistent with the statute 6173, which defines, quote, alternative dispute resolution means mediation, arbitration, conciliation, or other non-judicial procedure that involves a neutral in the decision-making process. Our procedures in the courts, in the court-appointed programs, are not non-judicial. They are judicial procedures, and as such should be exempted from this and not covered. I have participated in trying to craft what I think are good ways to protect consumers in this other arena, which is the private ADR arena, and where I think there has been a void. And I think that in enacting 6173, that the legislature recognized there was a void and pointed to the good work that was being done and pointed to having procedures that would be equivalent to the CRC that is used in the state courts, which is similar but not identical to what we do in the federal courts. Namely, that there is a complaint coordinator in the federal court, in the district court, that program that I run. I'm the coordinator, but then if I cannot satisfy everybody, I escalate it up, goes to a liaison judge. If the liaison judge's ruling isn't adequate, it goes on to the next level judge. These are all confidential procedures. They are outlined in our rules. So I understood that this working group was authorized on behalf of the state bar to implement something where there is this vacuum, where there isn't adequate consumer protection. Now, as a result of our sub-working group on administration, there was a recommendation by Mr. Kelly with which I do not agree and I am strongly opposed to, and staff has joined in that recommendation, that the complaint procedures for this working group would be recommending and that state bar would be enacting would apply as well to cases that are run through the courts, that are in, court appointed mediators or other neutral evaluators. And I disagree with that. It means that in order to do that, it would be, first of all, I think we're getting out over our skis. I don't think that the mandate from the statute authorizes that. So I don't
Ms.
think that this group,
Kopeikin,
excuse me, I don't think this group has jurisdiction to do it. Secondly, we
may I
have
just say, we're not discussing yet
excuse me,
recommendation on this point.
excuse me, you have not adequately, you asked for comment and it does not adequately represent the work of our group. I have
We're not making a recommendation.
two more very
on
brief
your-
points.
Okay.
Two more very brief points. If there are ADR local rules that if anybody on our program were to comply with the complaint procedure, they would be in violation of the ADR local rules. And then I would have to submit them to my court for sanction. That's problematic, obviously. So this actually could negatively impact our neutrals. It could negatively impact the the public that we serve who are getting pro bono services. And so this is a big concern. And I think it's something that really warrants discussion by this group and certainly public comment. So I wanted it to be aired in the public. Thank you so much.
And I completely agree. And I was up for a discussion about this issue at this meeting, and staff said this needs to be agendized if we're going to discuss it. It's a big issue. I think Ms. Kopeikin and I both agree. We want to propose changing the tentative agreement, the tentative recommendations already adopted by this working group to include something affecting courts. We have different opinions about how, but I think Ms. Hodgson, Ms. Kopeikin, and I all agree we want to discuss the interaction between court complaint proceedings and the state bar proceedings. But I was told by staff that needs to be an agendized discussion.
I'm sorry, I was following the procedure that we did before where Ms. Curtis allowed the people in our working group to add anything that they felt like they needed to. And I might not have been clear. It is my position that that any court appointed ADR process should be exempted from this in toto. Thank you.
I understand Ms. Kopeikin's point is that any court program should be exempted from the state bar proceedings. Is that right?
You mischaracterized what I said.
Not intention. Sorry.
Any court, thank you. Any court appointed mediator, arbitrator, E&E evaluator, when the cases where they're being appointed by the court, those folks those cases should be excluded. Sometimes there are panels where people can privately hire somebody and it is not the same process. I can't speak to those. I won't speak to those if they don't have a court mandated complaint process where there is a court ADR provider who is on a panel that is selected for the court by a court referral, and there is an existing complaint process. I think that complaint process is the one that should be followed. I disagree that this working group has the authority or should be purporting to do that. And I know that well, I don't know. I don't want to speak on behalf of the federal courts, but it is my understanding that the federal courts will not submit to this process.
Thank you. Ms. Hodgson and Mr. Weiner. And then I would note that we don't have a whole lot of time if we're going to try and adopt these recommendations. I'd like to get back to trying to do that. Please, Ms. Hodgson.
Yes. In the interest of time, I'm not going to reiterate what Jill just said, but say that I agree wholeheartedly with all of it. And my concerns regarding the effect that the proposed complaint procedure may have on state court mediation programs are also similar. What I would like to add is that I agree with the recommendations set forth by our subcommittee. However, I want to make clear that without this complaint piece, I believe that the recommendations are incomplete because no consensus was reached. And I do not think the work is complete, which raises a concern to me about going to public comment without having an opportunity either in our smaller group or in this larger group to have the very important discussion about court-connected mediation and complaint processes related to court-connected mediation. I think we cannot have a certification process without that.
Thank you. Mr. Weiner, please.
Thank you, Mr. Kelly. Since you have noted that staff said this can't be really taken up without being agendized, I just want to provide a brief explanation of the concern there. first of all, actions taken by the working group do need to be on the agenda. There was an action taken by the working group back in April when it adopted a proposed complaint procedure. The discussion of the issues that Ms. Kopeikin has raised and Ms. Hodgson has joined with impact that complaint procedure. I think staff and Mr. Kelly and agree that the discussion needs to take place. It just needs to take place in the context of an agenda item that proposes a revision to the process that the working group has already adopted. So that was the reason why we didn't think it was correct here. Also, just going back to Mr. Kelly's process, this isn't on the list of recommendations for the very reason that the subgroup didn't reach a consensus on it. I believe the matters set forth in that Mr. Kelly had been going through are matters on which the court did reach a consensus. So I think the plan was to see whether the working group can adopt those matters as proposed or with modification, and then come back presumably at the November meeting and address issues that the subgroup didn't reach a consensus on, and also including this question of courts and complaint processes.
I'll just note that there were other issues that I thought were very important that we couldn't reach consensus on, and they're not in our recommendations. And what I'm hoping to do today is focus on what are the contents of our recommendations. Please, Ms. Kopeikin.
Thank you. Respectfully, the language has been changed between the last meeting and this meeting to define things like providers as, took out non-governmental agencies. It did track the statute, and those changes have been made. This is when it became clear that that procedure was was purporting to lay over the court proceedings. So it's not that was not clear before. It has now become clear. And respectfully, our group might have had consensus on this. You declined to take a vote on it. So we could do that first, and then we could, I guess, agendize it for next time. But this issue is one that at least 2 of the 5 of our members wanted to have a vote on it being excluded. So I guess if it's not procedurally proper, then I will simply object to and abstain to. I do not join in the working group. Things I share Ms. Hodgson's view that it's not complete.
I have a question. Ms. Kopeikin, your concern, is it one of the 17 items that were discussed by Mr. Kelly?
I think that it is not specifically in one of those listings, Judge Pichon.
Okay, all right. So your position is understood. And that means that it will be discussed. So the fact that it's not in one of the 17, as I understand it, it means that your concern will not be voted on or eliminated from discussion. It's something that it appears needs discussion and it's understood will be.
Understood. Thank you, Judge Pichon.
All right, I'll turn back to Mr. Kelly.
Well, I'm going to go back to trying to follow the process unless there's other burning questions or comments, which is that I move that the recommendations of our subgroup be adopted as they stand. And if that doesn't pass, assuming there's a second, if that doesn't pass, then we'll try and figure out what we need to eliminate and hopefully adopt most of them. So I so move. If there's a second, then we can see whether they'll be adopted or not. And if not, we'll go back to discussing which ones are the blocking objections that people have.
Is there a second?
I second.
And I'm sorry, who?
Claudia.
Oh, thank you. Thank you. I see you, Ms. Coulter. All right.
Judge Pichon, I'm going to put up, I'm sorry to interrupt. I'm going to put up the resolution for the item.
Thank you.
So everyone can see it.
Is everyone able to see that?
And
Can you make it a little bit bigger,
Sure.
Ms. Ellis?
let's see.
down to, yeah. Thank you.
Better?
Yeah, thank you. All right, we have a motion and a second. And has everyone had an opportunity to read the resolution? Oh, yes, Dr. Getz?
Like to try to suggest a friendly amendment, if that's and so going back to 5G, Ron, I would propose that in addition to the verbiage you see there, that you might consider putting in some additional verbiage. However, the working group should continue to investigate alternative methods of background checking.
I would certainly accept that. Does the second amendment, does my second accept that as a friendly amendment also?
Yes, I do.
You said
Thank you.
5G? You said 5G.
Yes.
All right. And Ms. Hodgson.
I think I have two friendly amendments since we're adding, my first is the recommendation to go to the Board of Trustees or is the recommendation to go to public comment? That's my first. And the second would be if we're adding to consider alternatives regarding background check, that we also continue to consider the complaint process with respect to court-connected mediation.
Yes, I can modify the language that the recommendations is modified, go out for public comment.
Thank you.
Is that the?
I'm happy to accept that as a
Okay.
friendly amendment. Ms. Coulter?
Her second, about the court connected programs, is that what
Let
you're?
me take these one at a time. One of them was that we're talking about this going out for public comment as opposed to being submitted to the Board of Trustees, if I understood it correctly.
Yes.
Yes, I'm in agreement with that.
Okay. No, I'm afraid I do not accept the idea that well, I don't want to have that as part of this process, so I don't accept that as a friendly amendment. But I am in favor of it, and I'd like to discuss that when we're done with approving this recommendation. I was hoping that Ms. Kopeikin and you could have a discussion here in this meeting, and staff said it ought to be agendized. So that's the way I think I'd like to proceed.
I understand that, and that's part of why I'm suggesting the friendly amendment so that it's almost a place marker, but since we cannot discuss it at this meeting, acknowledging that there is still work to be done.
Yes, there absolutely is. So we're just trying to find the areas where we can agree today, but it certainly doesn't prevent us from discussing the outstanding issues that are remaining, and that's a big one, and we're not going to forget that one. And that will go back to the subgroup. Ms. Curtis?
Yeah, I just would like a clarification about the process that we're following because I have a couple of things that I wouldn't, I would, I want to prove on this first vote, but I'm not clear about whether it needs to be a friendly amendment or exactly how we, I'm not sure about the process. If I object to something, what do I do? Just vote no on the whole thing?
That
Or?
was my thought, but the other alternative, as I was proposing this, is that if it's a friendly amendment, and we can take a quick poll of the group, as I just did, how many people think this is a terrible idea? Fine, we'll take it out of our recommendations. My aim was to try and get as many of these approved today as possible, and if something has to get pulled out, we can pull it out. Do you want to just tell me do you want to make a friendly amendment? Do you want to?
Well, I'll give you, I'm not prepared to go through the whole thing, but I'll looking at 5B, attestation of completion, where it actually says that you need to keep a log and all of those details. If you're asking for people to say what I'm saying is true, then why not let that be up to the individual and that it's not submitted to the state bar, so it has the virtues of simplicity and efficiency. keeping costs down administratively. And then if there's a random audit, then they have to come up with it. And if they can't, that's their problem. But people sort of take it on themselves to do whatever is going to allow them to respond to any audit should it arise. So
I thought that was the intent of this. Maybe we could see that up on the screen when we get to it. I'd like to deal with because I thought we were intending to have people not have to submit to the state bar with their application each of the cases that they are claiming as experience and each of the continuing ed things they had, but to keep a log of it. So maybe we could go back to the wording of it when we get to that. I just want to make sure that we are finished with the issue of the interaction between the court processes, both whether they're judicial or non-judicial, whether they be covered or not, and whether or not the reporting requirements are to be done from the state bar to the courts and the courts to the state bar. It's a big issue, including the confidential information. And I'd like to make sure we do discuss it, ideally at the next meeting. But I don't want that to be part of our recommendations from the subgroup. So it's not accepted as a friendly amendment for what that's worth. If that means that the whole thing goes down, then we'll have to go back and maybe take that one out in some way. So in terms of Ms. Curtis's request for either more information or friendly amendment, staff, could you put up 5B so we can see, is that what you're talking about?
Yes.
Listing your training 5B. Could you put that up in front of everybody so we can see that and we can all look at what it actually says? So I'll just read it. Attestation of completion. So you're attesting that you've completed the baseline requirements, including maintenance and training of experienced logs. So what we're intending is that the practitioner do what I think you're asking. Keep your own log.
No, I'm asking to take out
yeah.
Maintenance of training and experience logs that list qualifying training and experience. I'm saying, people will do it in whatever way makes sense for them to be able to prove that to the state bar that they are in compliance, and we don't have to direct them to keep logs, maintain logs, or whatever.
I'm sorry, that's not accepted as a friendly amendment. And we'll see how many people vote this down.
Okay.
Did you have another point you wanted to?
Let's just move on and we'll see what.
Okay, Mr. Yamshan, please.
Yeah, okay. So with all due respect, Ron, I realize how incredibly hard you've worked. And but I think we're kind of getting into a mishmash of process here, to use a strict legal term, because we have a motion on the floor, yet you've offered an alternative approach to it. And I think a lot of us have real questions. There'll be more questions after public comment, I'm sure. So I think rather than amending this all the way to Hawaii, that it might be time to call the question.
If I understand Rosenberg's rules of order, that is a motion that needs a second, and it's a separate motion that gets voted up or down, which is basically to cut off discussion. Is that your understanding also, Judge Pichon?
I didn't mean to cut off Mr. Tuckman, by the way.
Well, I think that's what a motion to call the question means, is that we now go to a vote. And I think that requires a separate vote, requires a separate second, as I understand Robertson's rules.
Okay.
Are you making that motion, Mr. Yamshan?
I will call the question. My understanding of Robert's rules is it does curtail discussion, but it doesn't need a vote. It calls for the vote.
I don't think that one person can simply cut off discussion, and under the rules we're operating under, which I've read 3 times now, I believe that's a motion.
Just to clarify, I lowered my hand.
Okay. All right, Mr. Tuckman.
I have no comment.
All right, so there is a motion and a second on the floor and a call for the question. So why don't we go ahead and follow through with the procedure that was suggested? If it fails because people have issues with any of the one of the 17, um, with the amount of time that we have left, we can just agree to take out the ones with issues. And at least there'll be some recommendations that everybody agrees on that can go through. But I want everybody to know we're still at our subgroup stage. Nothing is ready to go out for public comment. We're still going back to our subgroups, and I think all subgroups have at least 3 meetings after this. So, Mr. Pileski, I see your hand up.
Yeah, I really appreciate the work. I feel as though we're allowing the form to take precedence over the substance. I think this is all really important and people are raising interesting issues and we should try to reach consensus. And Robert's rules, Rosenberg's rules, I just want to make sure that what we have and put out for comment is good and quality.
Okay,
All
well,
comfortable with.
we're a ways from public comment, so we're not ready for that. This is just our group. Ms. Curtis?
Is it possible to take these one at a time? Because there are lots of them that I'm fine with and some that I'm not. And then we could just see, that's a pretty efficient way of seeing what's left and what's left to discuss.
There is another process on the floor. I'm going to have to go back to the maker of the motion to see if you would like to withdraw that and do them one at a time, or if you want to continue because you do have a motion and a second and a call for the question.
I'm sorry.
I was told that an hour was allocated for this whole thing, and I was asked to try and see whether we could submit some recommendations and finalize them today. It's fine with me to vote on each one of them individually, but I think that's going to take up pretty much the entire afternoon if you want to do a roll call on all of 34 points. So, Madam Chair, I'm at your leisure. However you'd like to do it is fine with me. Maybe staff has a comment.
There is a motion and a second. We might as well follow through with what has been started.
Okay.
And so if it's okay with everyone, I'll just ask Angela to call the roll.
Okay. Armstrong, Coulter,
Yes.
Curtis,
No,
Dinkin,
Yes.
Dubois is absent, Ellis,
no,
Dr. Getz,
Yes.
Taguchi,
No.
Hodgson,
No.
Jones
No.
is no, I'm sorry. Kelly,
Yes.
Kopaikin,
No.
Cruz is absent, Lowe is absent, Judge Lucky,
No.
Valevsky,
No.
Robertson,
yes,
Tuckman,
No.
Welch, Chris Welch,
Yes.
thank you. Yamshawn
No.
and Judge Pichon.
Yes.
7 yeses and 10 noes, so the motion fails.
All right. So the next thing that we can do, and let's see, the time is 3:04 and we gave it till 3:30. We've already had a presentation regarding them. So if you'd like, we can just go through each one and take a vote. And that way, if there's some everyone agrees on, we can move on from that and the subgroup can go back and discuss the ones. Yes, Mr. Weiner?
Yes, Judge Pichon, I'm just wondering whether it might make sense to do a quick straw poll on each one before doing a roll call vote, just to see if maybe you can get a sense ahead of time about, whether it's going to pass. And if it is, then take the roll call. And if it's not, then maybe move on to the next one.
Okay, so a straw vote in addition to the roll call?
No, before the roll call. So if everybody seems to be comfortable with approving it individually, then you need to do the roll call. But if there's a lot of opposition, then you might save the time of the roll call.
Yes, good point. All right, so as Mr. Weiner said, we can just take a straw vote to see if you'd like to do it that way. if you'd like to go through each one and take a vote. And so for a straw poll, is that a show of hands, Mr. Weiner?
Think-
You're on mute.
I'm sorry. I think as long as everybody is on screen, just a show of hands would be, shall we take a vote on this one? Shall we take a vote?
Oh, so go
On
through,
the next
oh, your suggestion is to go through each one?
Yes, but just not to do the roll call before, do a straw poll and then do a roll call if it looks like it may succeed. If you prefer to just do a roll call on each one, that's fine also. It's going to take more time.
Okay. Does anyone else want to be heard on that? We can do that. All right, so I'm going to ask Mr. Kelly if you'll just, without a discussion, we'll do the straw poll of each one, and then if it has enough people, we'll go ahead and take the vote. Was that your suggestion, Mr. Weiner? Okay. Mr. Kelly?
Okay, so hands up if you like number 1, separate certification for mediators and arbitrators. You'd vote yes on that one? Or do you want to do it the reverse? People who have an objection?
No, that's good.
Okay. People who are in favor of number 1, separate certification for mediators and arbitrators. Can we just see a show of hands? Okay, so do you want to proceed on a roll call? It doesn't look like a majority of hands to me, but
I'm seeing mixed hands. Some people have their virtual hands and some people have their physical hands. So maybe my idea wasn't as helpful as I hoped it might be.
people would like to do a separate vote on each one of these by roll call. That's absolutely fine with
Yeah.
me. Preferable process, but
Yeah.
I thought I was supposed to do this in an hour, so.
I thank you for staying within your hour. So, okay, we will put our hands down and let's go through and take an actual vote. I'm sorry. We'll
Wait.
just take a roll call.
Does Mr. Tuckman's hand up mean he has a question or something to say? Okay.
Mr. Weiner,
Yes,
your
may
hand.
I ask, maybe if you put up the document as they're going through it so they can
So
see more clearly what they're going for.
is there a motion? Oh,
Not the resolution, but the actual
I'm
the
sorry.
recommendations, the attachment
17
to the memo.
recommendations. Okay. Go ahead, Mr. Kelly, and then I'll ask Angela if she'll call the roll after you just announce which one we're on.
I think I would prefer if somebody makes a motion and somebody seconds it, and then you can take a vote.
Okay.
If
That's
somebody
fine.
wants to make a motion saying, I recommend we approve number 1, I recommend we approve number 2, that's a motion, I think. I'm not going to make every one of these. If somebody wants to make them, they can, and then we need a second, then we need to vote.
I recommend that we approve number 1.
Second.
And Angela, would you please call the roll?
Armstrong,
I'm going to abstain since I just joined the meeting. I apologize for being late.
Okay.
Coulter,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubow, absent, Ellis,
No.
Dr. Getz, Higuchi,
No.
Hodgson,
Yes.
Jones,
No.
Kelly,
Yes,
Tropican,
Abstain.
Cruz, absent, Lowe, absent, Judge Lucky is not here right now, Kulevsky,
Yes.
Maddie, Robertson,
Yes.
Tuckman,
No.
Welch,
Yes.
Yamshan,
Yes.
Judge Pishon.
Yes.
11 yeses, 4 noes, and 2 abstains, so the motion carries.
Thank you. Mr. Kelly,
yes,
do
ma'am.
you want to announce number 2 or do you want me to go through the list?
I'm happy to announce them.
Okay, go ahead.
I'll just summarize. Number 2, no separate certification for specialties like divorce or employment.
All right, is there a motion?
I move we accept number 2.
Thank you. Is there a second?
Claudia, I'll second.
Thank you. Angela, would you please call the roll?
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubo, absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Opakin,
Abstain.
Cruz is absent, Lowe is absent, Judge Lucky is not here, Pulaski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshawn,
Yes.
Judge Pichon.
Yes,
The motion carries on this one.
thank you. Number 3, Mr. Kelly?
So State Bar staff administering the program should have ADR training or experience.
I move we accept number 3.
Is there a
Second.
second? Thank
Yeah,
you.
Sean.
Thank you. Angela, would you please take the roll?
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubo is absent, Ellis,
Yes.
Dr. Getz, Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Opakin,
Yes.
Cruz is absent, Lowe is absent, Lucky is not here, Pulaski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshawn,
Yes.
Judge Pichon.
Yes,
The motion carries on this one.
thank you. Mr. Kelly?
Recertification every 3 years, staggered.
I move we accept this recommendation, number 4.
Is there a second?
Second.
I have a question.
Oh, okay, Mr. Pulaski?
How, how does it actually work in terms of if everyone's going to get certified in year 1, how do you stagger the 3 years? Just mechanically, how does that work? Normally, you'll have a 1-year term, a 2-year term, a 3-year term at the outset, but you're not going to do that. I don't think you're planning on staggering the certification initially. So just, I think it's a good idea, but just how do you actually plan on doing that?
If I may, some of the things that we've been thinking about, this is State Bar, in terms of staggering, is if it's every 3 years, having it almost like the attorney MCLE requirements, if someone has recertification based on their last names, so it could be staggered in that way, or periodic based on quarter. So it's a matter of managing it for State Bar staff, and specifically the way it would be staggered we haven't determined that, but it's something that's on the table.
Or Mr. Kelly? Oh, Ms. Copakin?
Yeah, Ms. Ellis, if a vote yes on this, would this enable you to do exactly what you've just described?
Yes, but I will say it as part of all of these recommendations, the State Bar hasn't determined that these are, like, for example, I know this recommendation is for 3 years. The State Bar is still considering whether 3 years is the appropriate recertification process. We've also contemplated, as we've talked about in the subgroup meetings, whether it should be annual recertification. But certainly staggered in terms of workload consideration is something that is important.
Yeah, my question was poor. I meant would we be, I understand that staff will make its own recommendations and they may or may not be consistent with what the working group does, but I just wanted to be sure that we weren't inadvertently hamstringing the state bar staff by suggesting this 3-year term.
Okay, thank you. No.
Mr. Weiner?
Thank you, Judge Bashan. I just also wanted to point out, one of the things the administrative subgroup has been apprised of, and it's something I think it's been working under, is that, you know, by nature, some of these administrative processes are things that are kind of subject to input from various departments of the state bar, like what kind of IT structure is going to support these kinds of processes. So some of these are a little bit different from some of the policy recommendations that the working group has been more familiar with. And so there is going to be more uncertainty about exactly how some of the things like this would be implemented. You know, to Mr. Pilevsky's question, you know, the IT department would have to weigh in on how the applications are going to be submitted in the first place.
All right. Thank you, Ms. Ellis, and thank you, Mr. Weiner, for that. Mr. Kelly, the next one?
I don't think we voted on that one, did we?
I don't know.
No, we
That was-
didn't.
No.
I'm sorry, that was number 4, right?
Yes.
Right.
Okay. Angela, would you please take the roll?
Is there
Yes, can I
on that?
get the second?
Oh, I'm sorry, is there a motion?
I think Ms. Curtis made the motion.
I thought we had a first. Who's the second, please?
Forgets.
Oh, okay. Thank you. All right.
Thanks.
Angela,
Okay.
would you please take the roll?
Sure. Armstrong,
No.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubo, absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
No.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Popakin,
Yes.
Cruz is absent, Lowe is absent, Lucky is absent, Pilevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pishon.
Yes.
Motion carries.
Thank you. Mr. Kelly, number 5.
So this would be 5A, I would suggest. Um,
Okay.
Since there were some discussions about one of the separate items here. 5A, so requirements for practitioner applications and recertification. The basic profile information include any organizational affiliations.
Uh, so moved.
Is there a second?
Second.
Or okay. Angela, would you please take the roll? This is on 5A.
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubo is absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Popakin,
Yes.
Cruz is absent, Lowe is absent, Lucky is absent, Pilevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pishon.
Yes.
The motion carries.
Thank you. 5B, Mr. Kelly?
So that would be attestation of completion of the baseline requirements, including a list of training and experience so that the practitioner would keep a log, the purpose of which is to have the state bar be able to audit it if they do, with sufficient detail to be verified if audited. And that was one where Ms. Curtis, I believe, wanted to change it or amend it in some way. So
Okay. All right, Mr. Weiner?
Yes, if I can, I just wanted to say one of the concerns or considerations from the State Bar staff in terms of implementation is having some uniformity of record. I know there were questions about, well, could the information be provided in a variety of forms, but if everybody is providing their evidence in a different kind of format, that's going to make it much more difficult and expensive for the State Bar to administer.
Okay, thank you. Is there a motion for 5B?
So moved.
Is there a second? Okay, it dies for lack of a second. 5C? Mr. Kelly?
So that would be that you have to attest that you're familiar with and will comply with the applicable ethical rules.
Is there a motion?
I'll make that motion.
Oh, that was Mr. Polisky. Okay, is there a second?
Second.
Angela, would you please call the roll?
Armstrong.
Sorry,
Armstrong.
abstain.
Thank you. Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois is absent, Ellis,
Yes.
Dr. Getz, Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopaken,
Yes.
Cruz is absent, Lowe is absent, Lucky is absent, Pulewski,
Yes. Oh, I made them.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
Yes,
The motion carries.
thank you. 5D, Mr. Kelly?
That applicant has to disclose any professional licenses and whether revoked, suspended in disciplinary processes, etc.
Is there a motion?
So moved.
Is there a second?
Second.
Thank you. Angela, and I know you sleep well tonight. Would you please take the roll?
Yes, Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois is absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopaken,
Yes.
Cruz is absent, Lowe is absent, Lucky is absent, Pulewski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
Yes,
Motion carries.
thank you. 5E, Mr.
Need-
Kelly?
An applicant will need to disclose any prior discipline.
So moved.
Is there a second?
Second.
Angela, would you please take the roll?
Armstrong,
Abstain.
Coulter, Curtis,
Yes.
Dinkin,
Yes.
Dubois is absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopaken,
Yes.
Cruz is absent, Lowe is absent, Lucky is absent, Pulewski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
Yes,
The motion carries.
thank you. 5F, Mr. Kelly?
Applications will need to be submitted under penalty of perjury.
So moved.
Is there a second?
Second.
Angela, would you please take the roll?
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubo is absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopaken,
Yes.
Cruz is absent, Lowe is absent, Lucky is absent, Pileski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Pishon, Judge Pishon.
Yes,
The motion carries.
thank you. FG, Mr.
Hmm.
Kelly?
Before I do, Madam Chair, I just want to be clear that what the motions are that we're voting on are what's printed in front of us on the screen and not my quick summaries. Is that accurate?
Oh, yes.
I just want that to be on the record as well.
Okay,
G, that we recommended that fingerprinting not, and live scan not be required.
So moved.
Second.
oh, yes, and Dr. Getz, your hand is up?
Yes, I just want to have some understanding whether the friendly amendment that I thought was accepted is part of this motion or not, and I put it in the chat in case for a recall for everybody.
All right, it's in the chat and
Should it
motion,
be?
I'm sorry, go ahead, Ms. Ellis.
Oh, I'm sorry, Judge Pichon. Should it be added to this? We're in a new motion, so I wanted to make sure should it be added to this
I have
motion?
asked the maker of the motion.
Yes, I believe it could be added right to the end of this.
All right, and was the second Ms. Curtis?
Yes, that's fine.
Okay, yes,
Okay.
Ms. Ellis.
I can find it. Yeah.
It's up a little bit more from what's on the screen. As
Yeah, I'm getting the language.
got it. Sorry.
Is that it accurate?
Dr. Getz, is that accurate?
Will work.
And Ms. Curtis, is that fine with you?
Yes.
All right. Angela, would you please call the roll?
Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubo, absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
No.
Jones,
Yes.
Kelly,
Yes.
Kopaken,
Abstain.
Cruz is absent, Lowe is absent, Lucky is absent, Pileski,
Yes.
Robertson,
No.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pishon.
Yes,
Motion carries.
thank you. Number 6, Mr. Kelly.
So requirements for provider organizations, 6A, that they should be familiar with and will comply with the applicable provider organization ethical requirements.
Is there a motion?
So moved.
Is there a second?
I will second.
All right. And yes, I see 2 hands up. Ms. Ellis?
I believe Mr. Pileski was first, but I was going to offer a friendly amendment.
Go, Jenna. Go.
I'm pasting it into the chat, and the friendly amendment would be, rather than write out A, B, C, D, instead refer to Cal Business and Professions Code 6173B1. And it's for requirements as listed.
Is that changing the language of the line next to number 6?
Yes, yeah. So rather than A through D, number 6 would state the applications for initial certification and recertification of a provider organization should require attestation of compliance with Cal Business and Profession Code 6173B1.
To the maker, yes, Mr. Kelly?
I think I understood that you were attempting to combine A, B, C, and D, or is it just A, B, and C?
My understanding is that all 4 of those are covered, but perhaps D is not.
I
So
don't believe D is covered in the statute.
you're right, Mr. Kelly. And so my friendly amendment would maintain D.
Okay, Ms. Ellis, before we ask if there is an agreement to the amendment by the maker of the motion, we'll just take some of the hands that are up, and I see Mr. Pileski. I'm sorry.
Yeah, I can take my hand down. We don't have ethical rules for providers yet. So it's just, I support the concept completely. I just hope we actually get there.
All right, and Mr. Tuckman? You're muted.
Yeah, thank you. I think I am in favor of this amendment. One of the, I talked about the concern I had earlier with a couple subsections here, and the ability of providers with large numbers of arbitrators and mediators outside of California being able to comply with this. Is this amendment consistent with what I've been trying to look through some of the notes I had, consistent with what the subgroup itself had considered? I'm recalling we talked about these issues somewhat. We talked about indicating that the provider organizations would require compliance with the ethics standards, as applicable, or the rules of conduct for mediators as applicable. And is that concept consistent with the language of the amendment here?
That was my hope, including when we get to the presentation before the provider subgroup, I was going to share a little bit more about thoughts in terms of possibly seeking amendment of the statute or suggesting that that might be beneficial. But I do want to make sure that, for example, I am tracking everything here, and in posing this amendment, I think I'm being a little sloppy. I would say, Mr. Weiner, you've captured my attestation of compliance with Cal Business and Profession Code that accurately, and then I would add and maintain A as written and D as written, because to some other points raised, those are not covered by statute.
Thank you. Yeah, I also just want to make sure that the work here and with this subgroup is harmonized with other groups, which is the provider subgroup. I think it's important. We don't want to have 2 different standards. Thank you.
Okay, all right. And Mr. Kelly, did you have your hand up?
Only to say that all we thought we were doing was following the statute here, and we could not come to consensus on some big issues about what about out-of-state practitioners, for instance, on the larger panels. So that's why what we did was to try and, as best we could, express what the statute said as we understood it. And there's a big issue to be determined, presumably by the subgroup on provider organizations. We weren't trying to overstep that subgroup's work.
Okay.
That's very much appreciated, Mr. Kelly. And I think that the main aim of the friendly amendment is to reference the statute itself so that it wouldn't be necessary, if the statute were to change to address some of those larger issues, to go back and adjust the language as restated here.
All right. So Ms. Ellis's friendly amendment was to take the language, including the red print, and keep A and keep D, but take out B and C. Is that accurate?
Yes. Remove B and C, maintain A and D.
Okay. Now, the maker of the motion, I don't remember who it is, but do you accept that? Is there, who is the maker of the motion? If not, we'll start again.
I might have done it if so, yes. If I'm the one.
Mr. Pilevsky, are you thinking it's you?
I remember loving the ethics rules. I raised my hand because we
Okay.
didn't have them yet. I'm not sure I was the made the motion, but
Okay, so
support
may
it.
I have a motion? No, no motion.
I'll make the motion.
All right. Is there a second?
Second.
Judge Pichon, if I could clarify, is that striking this B and C?
Yes. Is that correct, Miss Ellis?
Yes.
Okay. So make sure.
All right. So that's the way it reads now. And I have a motion and a second. Angela, would you please call the roll?
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
No.
Dinkin,
Yes.
Dubo is absent, Ellis,
Yes.
Dr. Getz, Higuchi,
Yes.
Hodgson,
Abstain.
Jones,
Yes.
Kelly,
Yes.
Hopaken,
Abstain.
Cruz is absent, Lowe is absent, Lucky is absent, Pilevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
Yes.
The motion carries.
Thank you. Number 7, Mr. Kelly.
So review and approval both of an initial application and recertification should include, so 7A, prompt acknowledgement of receipt.
Why don't we just try for it, Mr. Kelly, and see if it passes, and just include B, C, and D, and C, if that'll work.
Certainly fine with me. So A would be acknowledgement of receipt promptly. B would be notice of an application being incomplete or inadequate, an explanation and time to cure. C would be a 3-month time frame to approve or disapprove. And D would be to require an inclusion of an explanation with the denial. So that's all of 7A, B, C, and D.
Is there a motion?
So moved.
Thank you. Second?
Second.
Thank you. Angela, please call the roll.
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubo, absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Hopaken,
Yes.
Cruz is absent, Lowe is absent, Lucky is absent, Pilevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
Yes.
The motion carries.
Thank you. Number 8, Mr. Kelly.
Do you want to try the same routine and go
let's-
through all of them and see if it passes?
We can try it.
So shall I just summarize each of them?
Oh,
real-
wait.
Oh,
Yeah, I'm
Mr.
sorry. There's a hand up, right?
Go ahead.
Mr. Pilevsky?
Just a question, is there any contemplation of the revocation of certification before the 3 years expires if someone is violating the ethics rules? Is that part of the remedy section? What happens to someone who's an outlaw after being certified?
I don't know if we have an answer for that yet. I'll ask Dr. Getz, since you headed that subcommittee, do you recall if that was covered?
You recall that it was covered in the complaint procedures and the process that we developed, that there would be a possible revocation. There were less severe penalties for violation of the ethics code, but it certainly could be revoked.
All right, thank you for that. All right, so, well, let's go for it. Mr. Kelly, number 8.
So to summarize quickly, reasons an application can be denied. A, didn't meet the requirements. B, didn't pay with a 30-day notice to pay being required. C, didn't renew on time with reminders required to be sent. D, verified violation of ethical standards. E, prior discipline in the certification program or any licensing or professional organization. And F, verified lack of candor.
Is there a motion?
So moved.
Thank you. Second. Thank you. I think it was, yes. Dr. Getz, was that you?
Yes, that was me. I'm sorry.
Thank you. Angela, would you please call the roll?
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubo is absent, Ellis,
Yes.
Dr. Getz, Higuchi,
Yes.
Hodgson,
Yes.
Jones. I'm sorry, Katie, I didn't hear you.
Oh, sorry, yes.
Thank you. Kelly,
Yes.
Popaken,
Yes.
Cruz is absent, Lowe is absent, Lucky is absent, Pileski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
Yes.
Motion carries.
Thank you. Number 9, Mr. Kelly?
So if an applicant is denied, then they can request a review and provide an explanation of why they think the denial was improper.
So
Is there,
moved.
oh, thank you. Is there a second? I think I heard Dr. Getz.
Second.
Okay, thank you. Angela, would you please take the roll?
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubo, absent, Ellis,
Yes.
Dr. Getz, Higuchi,
Yes.
Hodgson,
Abstain.
Jones,
Yes.
Kelly,
Yes.
Popaken,
Sorry, abstain.
Cruz is absent, Lowe is absent, Lucky is absent, Pileski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
I'm going to abstain. I did not have a chance to make a friendly amendment. This moves so fast.
Okay.
Judge
But what I
Pichon.
would-
Yes.
Oh.
Motion carries.
Thank you.
May I add some time in the future?
Oh, I'm sorry, Mr. Pileski. Yes, if you think it's going too fast,
No, that was Daniel.
oh, I'm sorry, Mr.
Yeah,
Yamcha.
right,
I'm
right.
very sorry if you think it's going too fast. We'll slow it down.
Yeah, I've generally been able to keep up, but I
Okay.
was able to offer a
right.
friendly amendment on this sometime in the future. It's fine. We can revisit it.
All right.
But the review language is a little ambiguous. Hopefully, they will also provide a statement of why the application was rejected to the applicant so they can see whether or not they want to request a review.
Okay, thank you. Let's see. I believe we're on number 10.
So that would be a requirement that practitioners and provider organizations have an ongoing duty to comply with the rules and standards and disclose any information that might affect eligibility.
Is there a motion?
Sure, I will.
Mr. Pileski?
Yeah.
Is there a second?
Second.
Thank you. Angela, would you please call the roll?
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Deacon,
Yes.
Dubois is absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Copaken, Cruz is absent, Lowe is absent, Lucky is absent, Pulaski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
Yes,
Motion carries.
thank you. Number 11, Mr. Kelly.
So this is just a request from our subgroup to include something with public comment. Do you want to have a motion on this one? Fine by me.
That's fine. Is there a motion?
Okay, so just to summarize, we want to recommend that going out for public comment was the question of whether or not initial trainings, but not continuing education, should be required to be real-time and participatory, either in person or online, as opposed to simply watching a webinar and say, fine, I'm trained. So we wanted public comment on that question.
All right, is there a motion?
So moved.
Thank you. Is there a second?
Second.
Thank you. Angela, would you please call the roll?
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois is absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes?
Copaken,
I was briefly kicked out of the session. Is this 11?
This is 11.
Then yes, thank you so much.
Cruz is absent, Lowe is absent, Lucky is absent, Pulaski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
Yes,
Motion carries.
thank you. Number 12, Mr. Kelly.
So this would be the State Bar website should give the name and tier level of certified practitioners and provider organizations and list the general reason for any revocation or suspension of their certification without disclosing any mediation communications.
Is there a motion? Okay, I don't want to go too fast. I'm not hearing a motion.
I'll move.
Oh, okay. Ms. Copaken, is there a second?
Second.
Okay, Dr. Getz. Angela, would you please take the roll?
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois is absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Copaken,
Yes.
Cruz is absent, Lowe is absent, Lucky is absent, Pulaski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
Yes,
Motion carries.
thank you. 13, Mr. Kelly.
So this is that certification rule should include that certified practitioners and provider organizations can be audited.
So moved.
Is there a second?
Second.
Angela, would you please take the roll?
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois is absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Abstain.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Hopaken,
Abstain.
Cruz is absent, Lowe is absent, Judge Lucky is absent, Pileski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch.
Yeah.
Yamshan,
Yes.
Judge Pichon,
Yes.
the motion carries.
Thank you. Relief number 14.
So this is it. We recommend there should be lower fees for practitioners who do solely pro bono work.
So moved.
Is there a
Second.
second? Okay. Angela, would you please call the roll?
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois is absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
No.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Hopaken,
Yes.
Cruz, absent, Lowe is absent, Lucky is absent, Pileski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch.
Yeah.
Yamshan,
Yes.
Judge Pichon,
Yes.
the motion carries.
Thank you. Number 15, Mr. Kelly.
This is again a request for public comment on the suggestion that fee structure for provider organizations would be to have them pay the sum of all amounts that their individual panelists would pay, with full credit for any panelists that are individually certified. And we were asked to comment on this, so we did. But if this is more properly in front of the subgroup on provider organizations, seems to me if somebody wants to make a motion to withdraw this, that would be appropriate. But that's what our recommendation was from the subgroup.
Is there a motion for this number 15?
Also move.
Thank you, Ms. Let's see, was that Ms. Kopaken?
Copaken, yeah.
Okay, thank you. And Mr. Pileski, your hand is up.
Yeah, just a question about it. This is paying all the fees for individual panelists who are certified, or all individual panelists, whether or not they're certified?
I
And
think
what about, how is this,
for certified practitioners?
once they're certified? Okay, I'm not sure I understand it, but okay. And just as it applies to AAA, which is a nonprofit, were they intended to be excluded from this?
As phrased, I have to say that apparently they would be. You want to make a friendly amendment? I'm not the maker of the motion.
I will accept a friendly amendment that it would include AAA.
Perhaps we should clarify any nonprofit provider.
All right, is that all right with you, Ms. Kopaken?
Yes.
Okay, and Ms. Curtis's hand is up.
Yeah, I'm not clear. Does this mean that if a panel, a provider is certified, that the individuals don't need to get individual certification? I'm not
The
clear.
intent of this was just to, we were asked to decide about fees or make a recommendation about fees, not decide. And this was what we came up with as a request for public comment as a formula. So we're not commenting on whether, on anything that the certificate, that the provider organizations would have to do in terms of getting their members certified or not certified. That's for the subgroup on provider organizations. This was just how much should provider organizations be charged? And this was our recommendation that this formula go out for public comment.
Mr. Tuckman?
Thank you. I'm still not clear on what the amendment is. Maybe so if it could be rephrased, that would be helpful. Is it just to say state by certified provider organizations, or is it to add in state certified not-for-profit and for-profit provider organizations? Whatever it is, I'd like clarification on that. But I'm still unclear on what the intent is. Is the idea that provider organizations have an obligation to pay the fees of its panelists?
That was not the intent of our recommendation to go out for public comment. The recommendation, as I understood it anyway, and people are free to correct me, we were asked to comment on fees. We said, if you're only doing pro bono work, it ought to be a lower fee. Well, how about the fees for provider organizations? One formula to be requested to have public comment on was that provider organizations would pay a fee. If you've got 100 certified providers, you'd pay 100 times the fee of an individual provider. And that way they wouldn't have to do their own certifications if they didn't want to. And you'd get full credit for any of them that would pay their own individual fees. I believe that was the formula that was proposed.
In that case, I'm withdrawing my motion because I have some concern about providers being able to be certified and their individual practitioners not being certified. So I will withdraw the motion. Maybe I didn't understand it.
Madam Chair, may I make the suggestion that we withdraw this now, given the late hour, and let the subgroup on provider organizations make whatever proposals they want?
All right, well, yes, of course, the maker of the motion has withdrawn her motion, so yes, you can withdraw.
That's my suggestion anyway, just
Yeah,
proceed.
well, you're the leader of the group. If you'd like to withdraw number 15, you may.
Unless members of my subgroup have strong objections, I suggest we kick this over to the subgroup on provider organizations.
All right, we'll hear from them if they disagree with that, but I see Mr. Higuchi's hand up.
Yeah, my understanding is that we weren't going to deliberate over all these, every wording, and we were going to just vote based on how it's presently written, pending a friendly amendment or not. So, I'm not liking the direction it's going if we're going to start deliberating all this stuff.
Well, we're on number 15 now, and it's being withdrawn unless I hear otherwise from the group. We only have 2 more to go. So, but I appreciate what you said. And I don't think anybody expected it to go this way, Mr. Higuchi. All right, so do I hear from any other members of the subgroup regarding Mr. Kelly's request to withdraw number 15? Okay, number 15 is withdrawn. Number 16, Mr. Kelly.
That fees should be the same for mediators and arbitrators. And we're not commenting on any other kind of neutrals yet.
So moved.
Is there a second?
I'll second.
Thank you. Mr. Higuchi, your hand, okay. Did you have anything else you wanted to say, Mr. Higuchi?
Nope, pressed the wrong button. Sorry.
Oh, okay, that's all right. Angela, would you please call the roll?
Armstrong,
Abstain.
Coulter, Curtis,
Yes.
Dinkin,
Yes.
Dubo is absent, Ellis,
Abstain.
Dr. Getz,
Yes.
Higuchi,
Abstain.
Hodgson,
Yes.
Jones,
Abstain.
Kelly,
Yes.
Kopaken,
Yes.
Cruz is absent, Lowe is absent, Lucky is absent, Palevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pishon.
Yes,
Motion carries.
thank you. Number 17.
So this is the one that says the state bar should create an advisory panel, including practitioners from different backgrounds, organizational sizes and types, and areas of expertise.
Is there a motion?
So moved.
Thank you. Is there a second?
I will
Second.
second.
I'm sorry.
I think we had 2 seconds. All right, that's fine. Angela, would you please call the roll?
Armstrong,
Abstain.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois is absent, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Copaken,
Abstain.
Cruz is absent, Lowe is absent, Lucky is absent, Pulevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pishon.
Yes,
The motion carries.
thank you.
I just want to take this opportunity to say thank you to everybody in the working group. I pushed our subgroup really hard to try and get all these in front of you today, and I'm really glad that we were able to deal with as many as possible. Thank you.
Thank you, Ron.
Well, yes, and thank you also and commendations to Mr. Kelly and to all of the members of your group. I know that you worked really hard, and I know this wasn't the easiest process to go through today, but we still got a lot done. So thank you all. Ms. Copaken, I saw your hand.
I was going to ask a point of order, but I think you've already addressed it, so I'll hold it. Thank you.
Okay. Well, I think that everybody deserves a break. It is now 4 o'clock, and so we have another hour left. So would a 10-minute recess be okay with everybody?
Yes.
All right, so that'll be 4:12. We'll be back, okay? And thank you. Everybody is present. So we took our break, and now we're at item 2.2. We allotted that 45 minutes, so we may not be able, so we won't be able to do that. So how about 15 minutes if possible? I just don't want to keep everybody because your time is very important. If anybody has to go, I understand. But we'll try to get through the next two because the groups have worked so hard, and I think it's very important that we hear from them. So next we'll hear from the provider organization subgroup, and the lead is Jenna Ellis. And thank you and your group so much for all that you've done. And may we please hear your presentation, Ms. Ellis.
Thank you so much, Your Honor. Thank you, everyone. The provider subgroup has been working very diligently to come back with consensus and ideas to share with the group as a whole. We've met 3 times since the past full working group meeting. We also had a couple additional subgroup meetings with some of the subgroup members and staff. It's really been a commendable amount of time, thought, and effort that's gone into it. Today, because we still plan to discuss quite a bit more, we're coming to you with just tentative consensus points. We have 3 additional meetings that are scheduled after this meeting takes place. And during those, we're hoping to formalize a recommendation for the group. Staff, I think you might have seen, provided a pretty comprehensive report. I know our time is limited. I'm going to highlight a few things, but I definitely invite my fellow subgroup members to fill in any details that they want to make sure we discuss today as well. And just to give a shout out to those members, I was joined on the subgroup by Mr. Higuchi, Ms. Jones, Ms. Lowe, Mr. Pulevsky, Mr. Tuckman, and Mr. Welch. And so just to dive right into a couple of the points on my mind. First, we discussed the definition of firm or provider as in the statute, and initially reached consensus on using the definition that appears in the ethics standards for neutral arbitrators in contractual arbitration. At the suggestion of staff, we went back over that consensus and definition, and staff suggested that to the extent a governmental entity might choose or wish to be certified, they should have the option. And based on that, there was openness and no objection from the subgroup to changing that definition to now read as provider organization means any entity that or individual who coordinates, administers, or provides the services of two or more dispute resolution practitioners. The next thing, though, I really want to draw to your attention about the staff's very excellent and detailed memo is some what I'm calling jurisdictional questions. And these are things that Mr. Tuckman raised a little bit earlier during our meeting today. We have ADR providers, including representatives of them in the provider subgroup who have a nationwide presence. So they work with practitioners who have a practice in New York and may only touch, for example, a New York case. And this, for us, raises some concerns in terms of the statute as currently phrased, which, as Mr. Kelly mentioned, requires provider organizations to direct its mediators, its arbitrators to adhere to the applicable ethics standards. And so the rub would be that a large provider nationwide presence would be requiring their mediator in New York working New York mediations to potentially adhere to the ethics standards that the working group is putting together if the provider itself chose to be certified. There may be some ways to address this, but I think there's some consensus amongst members of the subgroup that a statutory amendment may be appropriate to address this jurisdictional reach concern. Another piece that we discussed is that the ethics standards for neutral arbitrators already do have application language in place that addresses the California reach, but the current draft of the mediation ethics standards prepared by the working group doesn't have a similar application reach. So we could consider addressing these concerns in that context as well. The other thing, and this is another jurisdictional consideration, but it's not something necessarily provider related, but we did discuss hypotheticals where, say, you have a certified practitioner, a certified mediator, and they are doing a New York case with New York parties. Do we believe that the mediation ethics standards should apply in full, and same, possibly with the arbitrator ethics, although I think they're clear on their face in that regard. And so those are questions that we really are grappling with and are happy to raise with the group as a whole to get your thoughts. In addition to those points, there was general consensus that there should be a single certification track for providers rather than provider certification in arbitration and provider certification in mediation. There was general consensus that we should not have a certain percentage of practitioners need to be certified, tied to similar questions regarding the reach of the statute, but some other considerations as well relating to the independent considerations of different neutrals on the panel. One thing, though, that we also agreed on in terms of this is that there should be transparency in terms of, say, who from the practitioners are certified and who are not. We are continuing to discuss exactly what that would look like and how that information could be displayed. Some other areas that we discussed required training of affiliated practitioners, and here and on some of these other items as well, I want to note that I saw from the administrative subgroup, it looked like and the tiers subgroup in particular, tiers more so, there was discussion of some of these items being in tiers, and that is something that we've also been grappling with. For example, at the baseline level, should providers be requiring certain of their practitioners, their California practitioners, for example, whether certified or not, to get a certain minimum amount of training? That there's general consensus there, but we're again countering the same jurisdictional questions in terms of requiring the same sorts of training for folks with practices entirely outside of the state. We also, and this is something that I think is very important to mention, we understand from the State Bar staff that Senator Umberg's office is expecting that there will be a set of ethical standards for providers. And with that understanding in mind, we met both in our subgroup and also in our subgroup to discuss what those ethics standards might look like. That effort is ongoing, and I expect us to spend a lot of additional time discussing it in our next couple of meetings down the road. That, I think, for purposes of our time constraints today, I'm going to pause there and invite my subgroup members to add in anything that they really want to make sure is raised today that I might have missed, or any corrections that they have either to my summary or to the staff report provided. Thank you.
All right, subgroup members. Well, Ms. Ellis, it looks like you've covered everything, and
I see
oh, yes,
Mr.
I see a hand.
Pileski has a hand.
Yes, Mr. Pileski.
I think everyone in the group is working well together and we're making great progress. I just think that there's going to be a point if we're drafting ethics rules where we're going to need to interact with the tiers group. And I'm not sure how mechanically that can best work.
Okay, Ms. Kopeikin.
I didn't hear the very end of what Mr. Pileski said, and I wanted to. So I think if I understood, overlaying what Mr. Pileski said after Ms. Ellis, is that you all are embarking on ethical standards, establishing ethical standards for providers, or is that something we're expecting to get out of legislation?
We are beginning as, yes, we are working on it, and we are using as a base the CPR Georgetown principles that were developed in 2002, and essentially working off of those to come up to try to reach consensus on a set of ethics standards.
Thank you for
Thanks,
clarifying.
Ms. Kopeikin.
I have another question, but I'll get back in line because it looked like Mr. Wiener wanted to say something.
Mr. Wiener.
Thanks. I just wanted to speak to Mr. Pilevsky's question about the interface between possible tiers and provider organization issues. And we are seeing a lot of interface across the different subgroups, not only the ones that are meeting now, but also, as you've heard, the ones that have met before and have come up with recommendations. And we do have the constraints around Bagley-Keene. And so we can't have a joint meeting of the provider organization and tiers subgroup. So because that would constitute a quorum of the full working group. So staff can carry some messages, if you will, back and forth, or notify each of the working groups about issues that the others are talking about. The other thing is that this working group is really kind of the place to reconcile those kinds of questions. So if the provider organization comes in and says, there should be ethics standards, but we think this should be in tiers, then that would presumably be reported to the full working group, and then the full working group would kind of take it from there. Thank you.
Ms. Kopeikin.
I know this is also a really hard topic, so thank you all for your hard work. Earlier in our discussion today, there was a topic about whether it's contemplated that a provider organization could be, let's just take a California only based organization, because Ms. Alice, you made valid and important points I understand about jurisdictional reach, but if it were just California folks, if a provider organization is certified, but do you understand it to be required that their individual participating members would also be certified? Or is it this subgroup's view that those could be separate? Specifically, for example, let's just say I have 100 providers in California and I want to get certified as a provider organization, but I have 100 neutrals and only 5 of them get certified. Does your subgroup have a position on that?
Our consensus reached was that at least for baseline certification, we didn't think it would be appropriate to require a certain percentage or number of practitioners that work for a provider organization to my apologies, are affiliated with a provider organization to be certified. That said, there was some conversation about whether, to Mr. Pulaski's point, it could be a consideration for tiers. But I think with the difficulties of the jurisdictional questions raised, the math gets trickier when you aren't just talking about your hypothetical and you're talking about some of these larger groups.
Thank you. So theoretically speaking, for example, JAMS, because we pick on them a lot, and I don't mean that seriously because we don't want to pick on them, but JAMS has a lot of providers in California. But so for example, JAMS, if Jill Kopakin, were associated with JAMS, I could opt not to be certified. JAMS itself might be certified, in which case I would say, Jill Kopakin, work for JAMS, a certified neutral provider. Yeah. Okay. Thank you.
That's correct. And in that piece, I think it was important to us in reaching this consensus that the provider in those circumstances would still, at a minimum, require adherence with the ethics standards for arbitrators and mediators, jurisdictional questions aside.
Thank you.
Mr. Kelly?
Thank you. So that is a good segue into a confusion I think I had about what I think I read in the consensus points here, which is on practitioner experience. Certified provider organizations should not be required to require that their practitioners have experience. So either I misunderstand this or I have a real problem with it. If I want to be certified as an individual solar provider, I need to meet the experience requirements. But if I get together with a friend of mine and we've both just gone through a training, I can form a provider organization and neither one of us has to have training, and I can recruit 20 other people with no experience, 20 other people with no experience, and we could all work for a provider organization that's certified. And either I don't understand this or I really have a problem with it. Maybe you can help me out.
Absolutely. Mr. Pulevsky, did you want to weigh in, or I'd be happy
I
to?
don't know that we discuss it exhaustively, but I think in the circumstance that you both described, that the provider organization itself can be certified, but I don't think the individual should pretend to be certified or to suggest in any way that because the provider is that they are. So I would have given a slightly different answer to Jill's hypothetical. I think that there should be some disclosure if you're not certified. That's just my personal view. We haven't really gotten to it.
Am I misunderstanding the intent of this so that, I and 3 other completely inexperienced friends could form a certified provider organization and we could all say we're panelists on the totally no experience provider organization, Inc.?
I think the truth is, Mr. Kelly, we hadn't spun out your hypothetical to that very gamesmanship type scenario. And it's something I certainly want to discuss with the subgroup more. I think there are other requirements that to be a certified provider, you would still have to meet. There's some other concerns regarding requiring minimum experience that go back to some of these same concerns about just the reach, for lack of a better way of putting it.
Any other questions? Ms. Ellis, thank you very much for a very fine presentation, very thorough, and we appreciate your work and the work of your group. Thank you so much.
Thank you, and I want to thank again everyone in the subgroup.
Can I just say one thing before
Yes.
you move on?
Of course.
In the ethical rules, which are not cited here, there are very specific rules about the provider having an obligation to take all reasonable steps to ensure quality training and things of that sort. So it's not as simple as hiring, anyone you want, because there are ethical obligations on the provider to oversee and to take all reasonable steps to assure some levels of competence. So it's still an open question, but it's not off the charts altogether.
Thank you, Mr. Pileski. Is there anything else? All right, then we'll move on to item 2.3, and that's a report and possible action on the tiers subgroup recommendations, and that's Dr. Getz.
Thank you, Judge Pashan. I'm not sure there's any action to be taken on our work in progress, but mostly here to inform everybody as to our process. And you've seen some of it posted, and you've certainly seen it in the discussion that staff has posted. So first, like all of you, I'm sort of blessed to work with a great subgroup, Ms. Curtis, Mr. DeBow, Ms. Cruz, Judge Lucky, and Mr. Yamashan. It's just been a great experience. We started out on this path with, I think, everybody sort of conceding that the statute didn't provide much guidance here on where we're going to go with tiers. The initial meeting was just to go around the room and see if anybody had preconceived notions about tiers. We came out with some introductory thoughts that everybody thought were maybe important about tiers, and you'll see that in the notes. Those aren't conclusions we reached as a group. Those are just everybody's input. But when we got around to saying, okay, where do we go next? I think the group was saying, we're not quite sure where we should go next. So fortunately, Mr. Weiner had introduced some materials from the State Bar DEI Leadership SEAL program, also used CIARB as a resource. He presented those resources, which were helpful, but not exactly on our path necessarily. So we then decided as a group that we would do what many of you do in your mediations. We decided just to brainstorm without judging. So the whole idea was just to everybody throw out ideas, don't judge them, just throw out what comes to your mind based upon the resources that Mr. Weiner presented. Don't try to judge them. We'll save that for a later meeting. And we did suddenly we came up with a robust, I think 40 or 45 items. Some of them were duplicative, but, and we entered them on a spreadsheet. And then we spent at least the next 2 meetings really going through and trying to place some judgment on them, just talking them through, putting some into, no, this wouldn't work for tiers. Yes, this could work for tiers. And in fact, we had a meeting yesterday, which is not posted in the room. It's not posted as part of our materials, where we finished actually all the items that had to be discussed. So again, when I say finished, it's not in tiers form. These are to sort of take the input of the group, what looks like it would be good for tiers, what looks like it shouldn't be in tiers. And then the next step, which is for our next meeting, is that staff and Mr. Weiner is going to lend his hand to try to take our input and put it into a tiers structure. And of course, there's many different resources you can rely upon to at least see what a tier structure should look like. I think the way I describe it for my group is to take us all back to school. Of course, being the educator, that's where I always go. And I talk about required courses and elective courses. And so taking some of the ideas that we've generated in tiers and what's required for the next level in tiers, and then a menu of items that may be possible. So practitioners could pick from a group of items potentially to qualify for the next tier. Again, this is all sort of hard to describe in the abstract, which is why Mr. Weiner is engaged in trying to put together a model that we can react to, and one that, you know, we can process. And the target is to bring it back to the working group for the next meeting. But it is amazing the process we've embarked on. I mean, I'm just really, I was pleased with how we had very divergent viewpoints, but we're able to collaborate and see some of the middle and where we could agree and where we couldn't agree. And so I'm very fortunate to have worked with my group and we've gotten this far, which is basically going through all the 40 some odd brainstorming ideas and getting some sense of what should be tiers and what shouldn't. And then the next step is to put it into a model. That's where we've been. I'll invite also any members of my subgroup to comment as they see fit.
Yeah, thank you, Jack. I would just like to add that one of the unexpected benefits of working with this group and the subgroups was working with and meeting with the incredible talent among the members. A couple of us just bantering ideas around. We developed some ideas to improve certain roundtables that we're doing with local bar associations. So outside of this process, we will be collaborating just on improving the ADR community in general. And it's just been phenomenally fulfilling that way. And I'm just grateful to work with all of you.
Thank you, Daniel. Anybody else from the subgroup want to comment on where we are, where we're going, where we've been? All right, so if there's any questions about the process, Dana, please. You're on mute.
Maybe you've mentioned this, Jack, but you know, we struggled with this idea that as in the legislation that says that the tiers will be limited to ethical issues, and we decided not to adhere to that narrow definition and to do what we thought made sense. So I just wanted to point that out, that we sort of ignored it, and maybe you could address that, Alan, so the rest of the people know why we took that broad approach.
Well, can I just, and Alan, or Mr. Weiner and Ms. Ellis, please correct me if I'm wrong. But Ms. Curtis, it's a good thing you took that leap because of the amendment to the statute. So would either Mr. Weiner or Ms. Ellis like to comment on that?
Or
I'll go
Alan,
ahead.
you want to
Take that one. I would frame things respectfully a little bit differently from how Ms. Curtis did. I don't think the subgroup decided. First of all, I don't think the statute specifically says limited to ethical issues. I think it says consumer protection and accountability, and ethics is a big part of that. But that's not the only part of consumer protection and accountability. Also, the working group, as you'll remember, you've had a number of questions in your meetings and discussions about, well, what does this mean, consumer protection and accountability? What can be included in that? What can't be included in that? Some of the subgroups that we're talking about, baseline requirements, we're suggesting, well, maybe this should go in a tier. And then there's a question about, well, could that go into a tier? And I think some of those questions specifically evolved around additional training and education, because if training and education, if you have more training and education, does that protect consumers? Because presumably you offer a higher process. And a number of working group members have suggested in the past, why don't we ask Senator Umberg what he meant by that, and what exactly the vision was here. And we did reach out a couple of times to Senator Umberg's office, and the first couple of times we were sort of told, well, that's what your working group is there to do, is to figure out what this means. And then we raised specific questions about education and training, and whether that would be something that, that the author thought fit into this tier structure as it was defined in the statute. And through that process, we did obtain we didn't obtain sort of the informal feedback we were hoping to have, but we had some discussions about whether or not the statute could be amended to clarify that. And every year, the state bar has what some of you may know as the state bar bill, the fee bill that covers state bar attorney licensure fees and a lot of other things. And that was carried by Senator Umberg, and as the chair of the Senate Judiciary Committee. And his staff expressed a willingness to provide some clarifying language with regard to tiers. And this is something that was, I think, made known to the members of the tiers subgroup, but I think this evolved after the last working group meeting. So it wasn't really, I think it was alluded to in the staff memo, but it hadn't really been discussed at a previous working group meeting. Senator Umberg, in the attorney fee bill, which covered the state bar bill, which covered things like the bar exam and other kinds of things, put a section in there, section 11, the last section, essentially said that tiers could include, education and training, and other matters, determined by the state bar. So that, I think, created a higher level of comfort in adding some of the things that the tiers subgroup has been talking about. I hope that answers that question.
Mr. Pilevsky, did you have some thoughts?
I did. And as you probably know from my past rantings, one of the issues I care the most about, that I really think impacts consumer protection and the perception of fairness, is taking additional cases during the pendency of an arbitration. So you've got a whole section there on disclosure and recusal. I think as you go through it, it will be helpful to separate mediation and arbitration, because I think the concepts are sort of different about additional cases. But I'm not sure that, and there's also two things in here which I think are required by statute, obviously: disclosure of the fact of prior ADR proceedings, and the disclosure of consumer case information. But I'm not sure I understand some of the ones in that bracket there. The commitment to allowing the challenge if they take on additional cases, refusal to accept new business from a lawyer while the proceedings in progress upon request of the parties at the outset. That was a yes. Can you just help me understand the distinctions that you folks were thinking about, of, like, let's say the last two of those, for instance?
Yeah, if I can just say, the bracketed language with the question marks, I think, reflects the fact that these are still issues that the subgroup is discussing. As Dr. Getz mentioned, these aren't firm conclusions. It's still a work in progress, and so rather than fully developing what's meant by disclosure about having conducted prior ADR processes, the subgroup had talked about, well, are we talking about advanced disclosure? When is this happening? Is it being the fact of the disclosure? So those were just some of the questions that were raised by subgroup members in putting together this list. And Dr. Getz, I apologize for jumping in if you wanted to take that question.
No, thank you for jumping in on that. And definitely still a work in progress. So, Mr. Pilevsky, appreciate all your input. Thank you.
All right, can you just help me just understand what you mean by the next to last one there? Because you said yes, so I'm happy about that. I just don't understand exactly what it means. Refusal to accept new business from a lawyer or party upon request of parties at outset of ADR process. What does that mean?
Dr. Getz, you want that, or do you want me to take it?
I'll have you take that.
All right. So the idea that came up, and this is something that there was discussion around this in the discussion of the mediator subgroup recommendations on ethical requirements for mediators. And there was discussion about, well, should this be, is this something that needs to be disclosed? Is this something, what if somebody objects on that basis? And so the idea here, I think this was landed in the do not, oh, I'm sorry, you're in the second one, the one above here that was the do include. I think the idea is that might be something that was developed further in the tier structure, that if a practitioner declined to take new business from a lawyer or party while a proceeding was pending, upon the request of the parties at the outset of the process, that might count towards getting them into something above a baseline tier. We're contemplating probably at least 2 or 3 tiers, and so which tier this would fit into. And as Dr. Getz mentioned, there may be some items that would be considered, equivalent to required courses. You need to agree to this in order to get into, whichever tier it might land in, and others that might be, we don't need to agree to this, but you need to agree to these 2, and you need to agree to 2 of these 3 other ones. So that's part of the structure that, is yet to be developed.
I like the sound of it. I'm just trying to figure out what it actually, in practice, let's say right now, the ethics rules say, if you check a box that say you're going to take additional cases, you can take additional cases. Too bad. This seems to say, and maybe I'm misreading it, but I like this rule. I'm not criticizing. I like it. It seems to say that despite what box you check, that if the parties up front say, thank you very much, we don't want you to take additional cases, you agree to basically uncheck your box, that you will not take additional cases if at the outset the parties say, we don't want you to. Is that what you mean, or is it something else? Or I'm misreading that.
I think that's a reasonable interpretation of, sort of the idea as it's been discussed and the limited extent to which it's been developed so far. But I mean, I think it could come out meaning pretty much what you have described.
It's an interesting variation.
Ms. Curtis?
Yeah, thank you, Jack. So some of much of our discussion in this area of transparency and disclosure and that sort of thing, from my point of view, it was a way of bringing in some of the heightened ethical commitments that were not passed in our discussion of mediation ethics. And the idea is that people can, if they choose, to adopt those policies that require a greater degree of transparency or disclosure as part of the way that they reach a higher tier, and that they wouldn't be mandatory, but that for those people who do it, there's some credit given, and that's what we're going to discuss about how that system might work. But for me, it was a way of providing some additional protections, as I see it, to the public, but on an optional basis, as opposed to requiring them under the statute, under the ethical rules.
Well, Judge Bashan, seeing no further hands, I think that describes our work to date, and we're looking forward to coming back with a more structured recommendation at the next meeting. And thank you all for your patience and indulgence.
That was a great discussion. Thank you so much, Dr. Getz, and thank you to each and every one of your subgroup members. That was excellent work. When you're starting from ground zero, brainstorming seems to work. So thank you so much. So now I'm going to turn the floor over to Mr. Weiner, Ms. Ellis, for any final comments that they would like to make.
If I can just start with this, hearkening back to what Ms. Ellis said at the outset when she was talking about the agenda, or the timeline, if you will, for this project going forward. One of the things that she mentioned is that, when we have comments coming back, we're going to be bringing those comments to you, as you've known all along. We're anticipating that in the March, April timeframe, we would like to send out a poll now and get some meetings on your calendar for that March, April timeframe. We're hoping that your calendars are freer now, and that we can maybe get a jump on reserving space there for some meetings before you fill them up with your other important activities.
Thank you. And Mr. Kelly, I'm going to come right back to you, but I'm going to go to Ms. Ellis and then come back to you. Ms. Ellis?
Thank you, Judge Pichon. I don't have anything.
Okay. Mr. Kelly?
So before you break up, I just want to come back to the question of how does our subgroup properly ask the working group to take up the issue all of us, I believe, want to discuss again, which is the relationship between court programs and the state bar and maybe designated professional organizations handling complaints. And I believe Ms. Kopeikin wants to expand that to a slightly related but a larger question. The statute does not define what a non-judicial process is. And the discussion could be widened to, should all court processes be exempt from the state bar complaint procedures, because there's no definition of non-judicial in the statute. In any case, I'd like to just ask, how do we go about getting that discussion back on the working group's agenda? That's all I wanted to ask.
All right.
Yeah.
Yes, Mr. Weiner.
Yeah, so thanks. If I can, I think that issue has been well highlighted in the subgroup meetings leading up to this working group meeting and in this working group meeting. So staff is aware of it. It is one of those issues. It's actually kind of a set of issues having to do with, the definition of provider organization, having to do with the complaint process that was previously approved, and a couple of other pieces rolled into there. So we're aware of that. And for the next meeting, first of all, we may discuss that further with some of you in your subgroups, and we will put it on the agenda, as an action item, so that if, for example, the working group sees fit to amend the complaint process that it adopted back in April, that will be properly before the working group in November.
And Mr. Palevsky?
And just a question, when we went through Ron's group, one of them, I think it was 5B, I don't have it up on my screen, failed for lack of a motion or a second or something. But there were two parts to it. One said you got to certify that you're going to comply with the training requirements, I think. And the second part has to do with the log. Obviously, we can't leave off the first part. So I'm wondering, just procedurally, is that going to come back around? Or is there going to be some discussion, because we can't leave that certification off?
If I can take that as well. As much as Mr. Kelly and his ABLE working group might wish otherwise, I think we're going to recommend that they not be disbanded yet, because I think there were some discussions that came out of that. I think that subgroup may also have some questions coming to it from some of the other two subgroups that are meeting now. So I think we'll ask Mr. Kelly and his ABLE subgroup members to revisit at least that question and see whether that might be reframed.
Thank you.
And we can, if I may, also include that as for public comment from staff perspective, even though it wasn't voted down here.
Thank you. Yes, and Mr. Kelly, I did see that, and you couldn't have thought you were done. So yes, I think it's a good idea for it to go back for discussion to the group. The subgroups have done a wonderful job, and it's hard to imagine that it could come to the group without something going back. So I have to just say that your group did exceptionally well as the other groups have also. So I hope that you don't mind with the questions that have been asked, that it means that your subgroup may discuss something again. But I just really appreciate the work that you've done, and I can't tell you how impressive it's been. So thank you all very much. Does anybody know when the next meeting is, or is that something going out for
November 20th.
November 20? Okay. Well, does anybody have anything else they would like to discuss or say?
I'll just add the following meeting is December 15th, as Ms. Mia Ellis had mentioned earlier in her kind of overview of the timeline.
Okay, thank you. All right, everybody, thank you so much for your hard work and your time. And I look forward to our next meeting, but you have a little break. Well, sort of, you've got your committee meetings. But anyway, thanks for everything, and I'll see you next time. Bye.
Bye. Thank you.